Legally Speaking with me, Tarun Nangia. Today we are dealing with a very, very interesting topic, that are Indian general counsels moving away from the arbitration process? They don't want to arbitrate anymore. Are they also insisting that in contracts we should remove the arbitration clause? Why they are doing so is what we are going to discuss today. And I have a very eminent panel to discuss that with me. May I welcome Senior Advocate Abhinav Vashisht. He joins me first on Legally Speaking for the first time. Welcome for some interesting interventions from your end today on the show. I also welcome Dr. Sanjeev Gevamat. He needs no introduction. He is well known as the head of the General Counsel Association of India. So he can give a picture which represents the thinking of the industry. In his day-to-day work, he is also the Group General Counsel and Group Company Secretary of the Dalmia Bharat Group, which we all know is one of the country's largest business group. Welcome, Mr. Gevamat, and looking forward to some interesting interventions from your end. I have with me Advocate Shashank Garg. He's an advocate who practices at the Delhi High Court and the Supreme Court of India. He's also a well-known arbitrator. So he can give us, in a sense, inputs from the arbitration end of the spectrum. And when that arbitration goes into litigation, Shashank, looking forward to some interesting inputs from your side today. At the outset, may I request in about 2 minutes, Advocate Shashank Garg, if you can lay the ground of the issues that we are dealing with today in terms of the reluctance of the GCs that we've been witnessing from the lawyers' end, and what can it lead to? And then we move on to the other panelists. Shashank Garg, 2 minutes to you for this.
Thank you, Tarun. Tarun, I think the first question that you must ask before we assume that GCs are moving away, whether GCs are moving away from the arbitration process or not, to which you will get a mixed response. Depending on the victims, if I can call, of arbitration process, and some things that have gone wrong terribly for them when they have seen the arbitrations, and also beneficiaries of the arbitration process, your responses will be mixed. Some public sector undertakings would hate arbitration as a process, and so would many private corporations. And this is all because of bad experiences. And I'm sure when Dr. Gevamat takes over, he will explain, his experience with the arbitration process, from a general counsel's perspective. But you see, in the last 10 years, things have changed rapidly. When I say things have changed rapidly, I mean in a positive way. A lot of those difficulties which were being faced by general counsels or parties to an arbitration 10 years ago are now decreasing, and they're likely to decrease even more. But every now and then we see some new issue comes up. And then there are some pathological issues with the arbitration process in India, which keep coming back and haunt us. So I'm sure the chain of events that we are seeing is towards a positive side, and we can continue to improve arbitration ecosystem in India only if issues that GCs are facing are addressed time and again in a proper manner, not just by bringing amendment after 5-7 years, not just by 1 or 2 judgments, but every stakeholder understanding their responsibility and also accountability for doing anything wrong. The difficulty with the arbitration ecosystem is there is no accountability of most of the stakeholders for whatever they want to do. So that's the real reason why there is this discussion that we are doing today, that why GCs are moving away from arbitration. And I'm sure Dr. Gevamat and Mr. Vashisht will enlighten you more.
So thank you for that input. I'll go to Senior Advocate Abhinav Vashisht. Now, you are a litigator. You appear before the Delhi High Court, the Supreme Court. You also do arbitration. So you see both sides of the spectrum in your work. When you see that the general counsels, who in a sense are responsible for the arbitration and the litigation happening in this country, if they are somehow not satisfied with this, what can it lead to? Because this raises from 2 questions. When anybody commits money to Indian business, he may be an Indian practicing in India, working in India, or an investor from the UK, US, Australia. A lot of money is now coming from Japan also in this country. And he doesn't get faster dispute resolution. What will it lead to? When you want the judiciary also now wants that we have a flourishing ecosystem in this country of arbitration. The judiciary wants it, but we don't see that happening. The infrastructure is in place, but there are problems which are now cropping up sometimes on fees, sometimes on delays. Can you in 2-3 minutes address all these issues for us?
Definitely. Thanks, Tarun. Look, I have varied experience. I would totally agree with Shashank that it all depends on what the experience of the party was. I have represented PSUs for now about 35 years, a few of them. I have, of course, appeared for some international bodies and even other corporate entities. What I have found is and I'm not talking about the result, you can win or lose. Of course, everybody would love to win. But if the process works well, if the system works well, nobody would mind arbitration because the kind of time that is required, please, we have to remember, arbitration is what we call is the original side of the litigation. There is trial, there is evidence. Of course, we are heading towards a stage where documents will be read for themselves and we won't have to do too much cross-examination and save time. But the kind of time that is required to lead evidence in courts, unfortunately, the courts are bogged down with the number of cases and you can never have the same kind of effectiveness and the time required to appreciate the various documents. So like I said, it depends on which client has suffered and or benefited in terms of the process. My experience, of course, is that certain GCs definitely do believe for various reasons, and we will not really go into all of them, cost, of course, being one of them, and delay being the other. Cost being one of them and delay being the other. And I'll tell you why delay. The multi-layered appellate or objection forums that have been put up, because when an award comes, for example, let's talk of Delhi High Court. You have an original site jurisdiction, the objections come to a single judge. From there, in 37, you go to a division bench. And from there, you can always file an SLP, and depending on the quantum and the issues involved, your SLP can be admitted, and it may take a couple of years for it to be decided finally, because everybody has a lot of number of cases to do. So therefore, yes, delays happen. When delays happen, costs will always escalate. Two, when we talk about costs, I must, because this was shared with me by one of the GCs of a PSU, their problem is that when the contractors file claims, they can be exorbitant claims and untenable claims. But because there is no court fee payable upfront, then leading evidence on these untenable claim itself takes a number of hearings, which actually will be dismissed towards the end. But the cost of the arbitration needs to be shared from the very beginning. So it's a very interesting point that the defendant also, the respondent also starts sharing the cost, and he or it may not have even filed a counter claim. So that's a big worry for them. And ultimately, not every time the costs in India are awarded always fully, or many a times, and we've read so many awards, and each one of us will agree, which says costs to be shared by the parties. Typically, that's an order that comes many times. Of course, arbitration is much improvement now in India. The costs are apportioned properly, but many a times costs are not awarded because the arbitrators do believe that perhaps somebody had a case, but maybe not tenable enough for them to have awarded it. So sharing of costs itself is a problem. Number two, like I said, the delays is a problem. And even if you are successful in getting an award, if it takes another 5 to 7 years to execute it, another big issue. So yes, so that's the way I look at it. But ultimately, it is a very, very individualistic issue. If you have been successful, if you got the money, arbitration is the best way to go forward because trial takes place. I've just finished an arbitration. We may have had about 70 hearings in it, absolute full cross, international witnesses were there. They were experts. They did a fantastic job. Of course, the honorable arbitrators were, they were retired Supreme Court judges, so they knew what they were doing. And I think it was a pleasure to do that arbitration, regardless of the time taken. So if you are, however, stuck in a situation where there are too many adjournments, the delay takes place, the costs will escalate, and it will always hurt a party.
Okay.
And that would lead to delay.
Thank you for giving that rounded opinion to us. I'll go to Dr. Sanjeev Giawat now. I don't want to ask you this as a general counsel or the group general counsels of a particular industrial group because you represent the whole industry with the GC Association of India, which you head. Now, I want to ask you two things. When arbitration was planned, envisaged in our country, it was planned to give quicker dispute resolution to business houses in commercial disputes so that the growth of the economy is not, in a sense, held up. You have quicker dispute resolution and you move along the way. In fact, a lot of times promoters tell me that when I'm executing a contract, there are disagreements that occur and quick arbitration should happen so the contract is being executed and small disputes that are being cropped up are also being sorted out. Now that does not seem to be happening. Secondly, sometimes there is an issue of fees. Can you share the worries of the industry, and what should India do to emerge as a hub of arbitration? Because if it is not a hub of arbitration for us Indians, then foreigners coming and arbitrating is a dream. Can you share these points with us?
Tarun, thank you very much. Thank you for inviting me. Very good question was by you, and I echo similar sentiments as Shashank and Savashis explained. Let us go to the genesis of this whole arbitration process. Why this 1996 Act came into existence? Because of the fallacies of the 1940 Act. And what were the fallacies? Fallacies were the unnecessary court intervention and time and cost. So Indian industry was very upbeat about the whole arbitration ecosystem when the 1996 Act came. But then the 2 decades of experience, which Indian corporates have experienced, it was so bad on multiple parameters. When I say multiple parameters, I say that multiple parameters in terms of the overall arbitration ecosystem. And arbitration ecosystem is not only with regard to time and cost. This arbitration ecosystem is also the quality delivery of the arbitral award. And I will explain to you what are the frustration. So my answer, the immediate answer can be that no, the Indian GCs, they are not moving away from the arbitration, but the fact remains that they are really frustrated. They are disappointed with the whole arbitral ecosystem. And why they are frustrated and disappointed, there are reasons on that. The 2 decades of experience suggest that from a time standpoint, we have not delivered. From cost standpoint, we have not delivered. And above all, one important element of the whole arbitral ecosystem was that we would have industry experts as arbitrators. The industry-specific knowledge was the prerequisite for an expeditious and the quality delivery of awards. But what happened? We ended up having an arbitral ecosystem whereby retired judges were the arbitral, they are the arbitral tribunals. Now, this ad hoc arbitration mechanism, which was largely based on, and which I normally say, a 4 a.m. clause and a 4 p.m. bar, and with the tribunal, with the retired people. Now, how this would be succeeding? I will just give you one simple example, and I have experienced the 1996 Act. There was a clause, I was working on one particular contract. The contract was with the Ministry of Defense. Arbitrator has to be appointed by the Ministry of Defense. The party approaches the Ministry of Defense, please appoint the arbitrator. Ministry of Defense doesn't appoint the arbitrators for 2 years, 3 years. At last, party, because there's a business relationship also, they don't want to litigate the matter. Ultimately, with no option, they approach court under Section 11. Arbitrator gets appointed. That arbitrator is a retired judge. He holds a few meetings, and typically the meeting happens for an hour's time. In an hour's time, 30 minutes get wasted in terms of gossiping with regard to the court corridors, etc. And also a certain amount of time in terms of refreshments and all that. Effectively, you end up having a 10-15 minutes of meeting. After a couple of years, the arbitrator passes away. He passed away. Another arbitrator gets appointed, and then the whole process goes on. Now, I'm talking about the first step in the arbitration process. I'm not talking about Section 34. I'm not talking about Section 37. I'm not talking about SLP. So this is the process in terms of appointment. I agree with this point that yes, the 2015 amendments, subsequent amendments, they were the milestone amendments. There's no doubt about it. There's no doubt about it, and they have added significantly in terms of the arbitral ecosystem. But Tarun, I need to mention one important thing, that we have improved a lot as far as ease of doing business is concerned. But you will be shocked that as far as the enforcement of contracts are concerned, we are still 163rd. And I will just give you one reason, it will take just 1 minute, and why it is happening and why this is impacting this arbitral ecosystem. That on enforcement of contract, we are still lagging behind because of the what? Because of the very fact that our courts, our arbitral tribunals, they have little respect for the terms and conditions in the contract. They go by equity. And that is when I say the quality award. I say the quality award because these retired judges, they have retired from an active judiciary, but then still in their mind, they act as if they are the equity courts. While Section 28 of the Arbitration Act specifically says that equity jurisdiction can only be exercised if the parties expressly agree to that. But still, you will invariably find the awards based on equity. And that is what the fallacy of the whole arbitral ecosystem is. So these are my initial comments, and please feel free to ask me further questions on this here.
One small point where after which I move to Advocate Shashank Garg, the lack of technical expertise you highlighted. Now, in the NCLT and the NCLAT, the National Company Law Tribunal and the National Company Law Appellate Tribunal, you have a provision for having a technical member. Do you think in arbitration, we need to make more use of such members in terms of seeking their assistance in deciding arbitral awards? Is that happening enough, or do you think that remains a problem?
No, Tarun, it is not happening and it will not happen so far as we will have the ad hoc arbitral process. Exceptions apart, it will not happen for the simple reason that wherever you have a tribunal of 3 members, essentially parties would always apprehend because the other party would be appointing some retired judges. The parties would not be coming forward in terms of appointing the technical person. While the original clause, even the United Nations, when this these standard model contracts or model clauses were developed, the thought was that there would be a technical persons from both sides and then a judicial member, and they would be deciding. But then that didn't happen. So effectively, what happens is that unless the parties write in their contract in terms of the tribunal that there would be 2 technical members, you ultimately end up in ad hoc arbitration, end up having the retired judges as your nominee arbitrators, and the presiding would always be a judicial member. So in a situation like this, it is not happening. The only answer to this is that if you have the institutional arbitration mechanism, a credible institutional arbitration mechanism established here in India, perhaps that might solve the problem. But then on an ad hoc arbitration, I have my apprehension that would solve the problem.
Okay, thanks for being so frank and giving an input. I think frank inputs lead to solutions, because I think the most important thing is identifying the problem. If we identify the problem right, then we will get to the solution. We'll take a short break and we'll go to Advocate Shashank Garg after the break. Welcome back. Just before the break, you heard Dr. Sanjeev Gemawat expressing what is holding back the arbitration system in India, why companies are frustrated with the arbitration system in India. Advocate Shashank Garg, I would want to ask you 2-3 things. Now, the Chief Justice of India is, in a sense, wanting India to become a hub of arbitration. You saw the establishment of an arbitration center in Hyderabad. You saw the establishment of an arbitration center in Gift City, mainly for companies who are operating out of Gift City for quicker dispute resolution. But then there were questions raised on technical aspects, as in the lack of technical expertise in arbitration, the time delay, the number of sittings, and the cost. If India needs to be a market where everybody wants to arbitrate, how can we improve? What are the first 4 or 5 steps in your view we should take to improve our situation from where we stand today?
Thank you, Tarun. Tarun, first of all, let me share with you, I have heard Dr. Gemawat 7-8 years ago in a conference, and I see that his views and anger continues to be almost identical, which is a reflection on, in spite of the amendments, the industry still requires some dramatic changes. And when I say this, I think one of the biggest stakeholders and the power really is rested with the general counsels. Dr. Gemawat made a very important point towards the end that in spite of him being interested in appointing a technical person, he may not do so because he has an apprehension that the other general counsel may choose a former judge. And ultimately, former judge and a technical person, if it goes in an 11, another former judge would be presiding, and the two may have a better equation. And we know we need not dwell much on that. But that's really, I think, the beginning of what I want to say. Of course, people like Dr. Gemawat, institutions like GCAI and other general counsel associations will have to come together and ensure that if they want to bring in this change, they do it collectively. I disagree with Dr. Gemawat on a point where he says that most of the retired judges still continue to behave as if they are judges. I think that used to happen, but after 2015 amendments, bringing in those kind of timelines, also because it is a free market, you perform or perish, that mode has actually kicked in. I would say largely, in my experience, those arbitrators are now in the exception side, not really the mainstream arbitrators. And of course, anybody who's defaulting, and I said that in my opening also, there should not be that fear that it is a former judge. I personally feel an arbitrator is an arbitrator irrespective of what background he comes from. He deserves the respect that he should be given of the position he holds at the tribunal. And we should not refrain from naming, shaming arbitrators, exchanging information if there are things that are, unpardonable. I'll give you one very simple example, and these small steps can be very, very helpful. There was a conference hosted by ICC, and Justice Pratibha Singh, I had posed a question to her, asking her that when in a 34 an arbitral award is set aside on the ground of bias, should the arbitrator not be named in that judgment? She said, in fact, she supports this view that an arbitrator must be named in a 34 if an arbitral award is being set aside on the ground of bias. It should become public information. These things need to be exchanged amongst the GC community, amongst the users. Ultimately, the frustration and the benefit is passed on to the GC. Like senior advocate Mr. Abhinav Vashish pointed out, we are only the catalyst in the process. The end user remains the general counsel and that's the client. So some of these steps, which are, even in the West, we see similar problems, but not as big as what we are facing in India. The second solution that Dr. Gemawat pointed out, and I completely agree, we've been talking about institutional arbitration for 15, 20 years, and I say the same thing. Who's going to start putting those clauses? The general counsels will have to incorporate those clauses with an institution. We see the general counsels are more comfortable putting the ad hoc clauses because of the nature of predictability. And after 2015, thankfully, because of Schedule 5 and 7 coming in, that predictability has now gone down. You cannot really have the same person doing your arbitrations again and again. So it has to really start from the end user. That is the general counsels and the clients. They must incorporate clauses where they may say that the arbitrators must have these technical qualifications. And there is no court, to my mind, no court with right prudence would overrule that clause and put a former judge if the qualification of the arbitrator is mentioned in the clause itself. But I must also tell you that in my experience, sometimes a tribunal who only has technical members can really be a frustrating experience, including for the client as well as lawyers, because of course they understand the technical aspect and their approach is very academic because it is a topic that they know so much. But when it comes to law, it's a struggle. So in my understanding, a blend of a technical and a judicial member on a tribunal is a perfect setup for the industry to get the desired results. And of course, for everything else, including enforcement of an award and the delays that happen in the court when we go to 34, 37 and SLPs, courts will have to proactively take certain steps. I see Delhi High Court is leading by example, and other high courts should follow that. I had pointed out in one of our previous debates that, and I'm not shying away from stating, Chandigarh High Court in a section 11 takes 6 to 8 months to issue notice. I don't think if 2 years, 3 years time is going to be taken for a high court to appoint an arbitrator, they're really going by the ethos of the act. So just one example off the cuff.
Thanks.
Everybody, we need to hold people accountable.
Thanks so much for sharing this at a time when India is seeing billions of dollars of investment coming in. The kind of disputes we are going to see is what we never saw since independence. It is said $1,500 billion will go into infrastructure creation in a phased manner, but disputes will be more than what we can handle. I'll go to Senior Advocate Abhinav Vashish. Sir, if you could tell me, if we don't find a solution, if we don't see to arbitration as a service that we give to the commercial world to get them to solve disputes, will that mean that if they don't move away from arbitration, they'll simply go to foreign seated arbitrations, they will go to other cities, and our aim and ambition to have a flourishing arbitration ecosystem will never see reality? Do you think that is the risk also we run?
Well, I greatly doubt that the Indians are going to go to any foreign country for arbitration. There are a couple of reasons for that. And one of the reasons is that it's not going to be cost effective. And that is always a concern for any corporate. But other than that, if the system has failed or the system does fail in future, right now, I believe there's a massive improvement. The only disagreement I have with Dr. Gemawat is this. At least in my experience, and I've done it for some time, there was a time that we could enjoy a samosa and a cup of tea for half an hour and actually get a date and come out. For counsel, it was fine. Whereas for the tribunal, it was good. But that was not the way to do it. It gave us no pleasure because as counsel, when you appear, the idea is to argue the matter or have something effective being done. In the last 10 odd years, maybe I'll put it 15 years, in fact, my experience is, if I can use the word, professional arbitrators are now there. We are doing morning hearings. We no longer can say, please have the matter after 4:30. We can't say that. The Honorable Arbitral Tribunal would say, no, you please come right now, 10:30 is the time. You'll be surprised, we start at 10:30. Yes, you may have a 2-minute chit chat, but you start, my experience is you go right up to 1:30, have a small break for lunch. The arbitrators are sitting before us and ready to start again. Yes, 5 o'clock we get up. So it depends on the tribunal, the selection. So persons are important. As it is true for the GCs, there are fantastic GCs and they do fantastically well. But if a GC does not perform, ultimately the corporate will tell you to move out. If a counsel does not perform or the filing counsel does not perform, they will move out. So today, it is my experience in the better arbitration, if I can use the word, the arbitrators which are chosen are mostly retired judges, and there's no doubt about that. And there's a reason for it. I think Shashank very rightly said that it is ultimately a legal process. We may call it quasi-legal, we may call it quasi-judicial, whatever. We ultimately land up in court. 2, that award that is made has to deal with all the issues that came up so that the courts that then deal with objections say, yes, it was considered. Now, those technical members, some of them are fantastic, of course, but they may get lost in the technicality of it. Look, I have done construction, I have done engineering, and you become an expert only to that limited extent of that case. So the judges, of course, they have to get out of the equity part of it. There is no equity jurisdiction at all. But other than that, there is experience of how a case should be handled. All I am saying is we have to choose the right people. If the choice is with the parties to choose the right people, could be a retired judge, could be a retired district judge. You don't even have to have a high court judge or a retired Supreme Court judge. Retired judges, in fact, Bombay, I believe now they're appointing senior counsel, younger senior counsel to act as arbitrators, and it's saving time and saving costs. So it all depends. How do you choose them? Who do you choose? And I do believe definitely one round of appeal has to be removed. You have chosen to go for that forum. It is an alternate dispute mechanism. Therefore, perhaps one appeal, it can go straight to the division bench, to 2 judges, and why not? If you are going to have retired judges who served as high court judges or district judges or even Supreme Court judges, why let it not go to a single judge at all? Make it a point, it only goes to high court and only to a division bench. And then only on limited grounds, anyway, we have limited grounds now. That way you can save some time subsequently. But we are talking about the arbitration before we talk about going to court. It is already time bound in many ways, but like I said, it depends on the matters. If you have a trial happening, if you have a counsel who says, I want to cross-examine and that document is disputed, there is no choice but to do it. But today, if you are there before, like court hours, you are also before the tribunal, it will save time. Nobody will go away from India. All we need to do is, we have to believe in the system. We have to strengthen the state system by having chosen people. For example, Dr. Gamawat can say, okay, I have chosen these 20 people. 10 of them are technical members, 10 are judges. And for the next so many arbitrations, these are the people depending on the dispute I have. So, and how will you do that? Because the GCs can come together. The legal heads of various PSUs can come together and decide, okay, this is what our experience is. This is how these learned arbitrators have performed. And therefore, we will choose from them. And of course, the other party, one party will always try to delay. maybe a PSU may not want to delay too much today because the world has changed and there may have been a time when you may have been slow. I think today we have to be competitive. So I believe that if you choose the right people, we can save this without any problem at all. And number one, and to make it cost effective, like I said, nobody's going to go out because I know what happens when you travel outside. Then not only does the officer go, more than one officer goes, more than one or two filing counsel goes, senior counsel goes, and sometimes senior counsel's own associate goes. So the cost factor, and then you have to charge differently. Everyone charges differently. So if you, and if you convert a dollar, I think every month you have to anyway add 5% extra. So yes, we'll be in India. We'll do well. It is only a matter of choice of people. I have, like I said, I've done a few arbitrations in the last couple of years where we were lucky. We had the right arbitrators, good arbitrators. Winning or losing doesn't matter. Incidentally, I may have won, it's okay. Incidentally, I may have lost, no problem. But they knew what they were doing. They gave us time to argue what was required, and therefore we finished. Yes, not immediately. We didn't finish in that ideal system of 1 year. It may have taken a little more. Of course, the pandemic came in between. But that aside, time may be taken, but as long as the parties are satisfied that they got a hearing, you can go to court and say, I want to defend this award because it has been written beautifully, or I want to challenge the award not done properly. But if I can avoid a stage there where I don't have to go, then perhaps I think India should do well. Whether institutional, let me tell you, it is not as if, and I have done FICCI arbitrations also, it all again depends who was the arbitrator appointed by the institution. Suppose I am landed with somebody who's not, and we don't need to have an expert in law. We can have an expert in the field of which the dispute is. If the learned arbitrator is not willing to work, what do? So FICCI won't be able to help me. The institution won't be able to help me. So choice of people, I believe, is the most important factor.
Point very well taken. I'll go to Dr. Sanjeev Gevamat. We're almost out of time, but two final comments from your end. Sittings and cost are something which are discussed a lot because not all companies are cash rich and many sittings multiply the cost with snowballs. You may be charging low, but if you're doing too many sittings, it definitely has an impact. Do you think that needs to be addressed?
Tarun, completely agree. And before that, I would like to say that I agree with Mr. Bashist and also Shashank. Yes, there are improvements as far as arbitral ecosystem is concerned. There are certain very good arbitrators, very good, this bar also we have developed over a period of time. So there's no doubt about it. But then coming to your specific issue on as far as the sitting is concerned, the cost is concerned, I would say largely in two words. The unprofessional attitude of the arbitrators, I think that needs to be addressed. And I'm very candid in my views on this, that unprofessional attitude is to that extent that, if you see any big arbitration, the arbitral proceedings would continue for 100 sittings to 150 sittings and so on. And every sitting costs a huge amount of money, not only from the arbitrator's fee standpoint, but then also senior lawyers and law firm standpoint. Now, and in a situation like this, you will invariably find general counsels getting frustrated that these sittings are what for. Just think about the situation, Tarun. The same kind of issues, if they are before the courts, whether these number of sittings are required, would they be holding those number of sittings? Answer is definitely no. But then in the arbitral ecosystem, they are holding those number of sittings. And let me give you one more comment. And with all due respect, we need to address the issues also. So that's the reason why I'm addressing. There's a great amount of, nexus or camaraderie or whatever you can say between bar and bench. In the first hearing, once the reference is done, when the first procedural order gets passed, your senior lawyer, he himself would be suggesting to the tribunal, my lord, you would be, reading fee would be extra and this counterclaim is extra and this, that, etc. Now, there's a relationship. There's a relationship among the bar and bench we can understand. But as a client, is it worth it? So the general counsels get frustrated because at that point of time, they don't have any option to suggest anything because they have that apprehension that they can't raise those issues. So these are some practical issues. I would make one more comment that today, of course, with the changes in law, today, as far as the smaller contracts are concerned, organizations are getting away from the ad hoc arbitration and they're going for the institutional arbitration. And there are, a few good institutions already available in India. You can talk about, Delhi Arbitration Center or Mumbai. That's some of the very good institutions. But then for smaller contracts, organizations are taking those chances. But then as far as large contracts are concerned, with the high stakes are involved, I would slightly disagree with Mr. Vashish that yes, organizations are thinking of having a foreign arbitration, as compared to the ad hoc arbitration. At least there would be certainty. At least there would be an understanding that the arbitrators would be deciding the matters based on the terms and conditions of the contract. They would be reading the contract, not based on the equity. So I think there's a shift happening. And I agree to that extent, Tarun, with you, that yes, the high-stake arbitration matters, I am seeing this trend that these are getting shifted to outside India, particularly in view of the recent judgments of the Supreme Court. Also, they are shifting away. So that is one risk which India would be facing. And once they get shifted, then the expectations of the industry of having a credible institutional mechanism here in India, I think that would be a big question mark. So we will have to do something about that. I agree with you, Tarun, that the kind of investments which we are talking about, Indian industry undoubtedly needs a credible institutional framework and a good arbitration ecosystem. Let's accept this reality that the litigation is not the solution as far as commercial issues are concerned. So with these words, I can conclude as far as the question.
Thank you so much for these inputs today. It was a very healthy discussion. We openly discussed the problems. And I would like to thank each one of you, Dr. Sanjeev Gebawat, who heads the General Counsel Association of India, Senior Advocate Abhinav Vashish, leading arbitrator and lawyer at the Delhi High Court and Supreme Court, Advocate Shashank Garg, very well-known arbitrator, as well as advocate at High Court and Supreme Court, Delhi High Court and Supreme Court, that the issues have been raised. Even the Chief Justice of India has made his intent clear that he would like to see India having a flourishing arbitration ecosystem. But unless these pain points are resolved, we don't see that happening. And secondly, I say this time and again, India has not seen the disputes that it will see in future. It is going to be much more that we can handle. And a lot of corporates may have ending up having bruises and may return back to their home countries if they don't see their money and money gets stuck. There have been instances where many companies have winded up operations because they couldn't manage business in India. Obviously, because they couldn't manage enforcing their contracts. That is why this episode, we will continue to follow this up and raise it every month, time and again, till some solution is found. I hope the viewers will find this useful. Thank you so very much. Thank you so very much.
Thank you very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.